Well. Happy Monday. I'm normally not live at this time or on Monday, but when stuff pops off, sometimes we just go live to talk about it. Answer questions, break it down. And today, the judge in the Tati Westbrook without a crystal ball case has ruled on personal jurisdiction and dismissed the case. We're going to talk about what it means, what I think might happen next, and answer all of your questions. Very, very excited to be here with you guys. Very interested in the court's ruling on this. Can't wait to see it. So let's hop into this and see what the judge has to say. So you guys, you're here. You want to talk about it. We need to just get into it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. As always, here, I'm going to pop that down for a second. As always, we are here to talk about the legal documents in this case, not the people involved in this case, even when those people act wild on social media. We are just here to break down what the court said, what the ruling means, what can happen next, and what I think about all of it. And of course, answer your questions. So yes, this case was dismissed on grounds of personal jurisdiction only. What does that mean in a nutshell? For those of you who are like, in a nutshell, the court did not rule on the merits. The court did not say this case is a strong case, not a strong case. Babs yeeted it and said, you don't go here. Like, I'm not the boss of you. You're not the boss of me. We're not doing this. So that is literally all that the court has said. We're not doing this. That's it. So could that have been a trial strategy with the amount of motions that the defense filed on this? Absolutely could have been. Could it have been annoy the court until she says, nope? Yeah, possible. Why do I think that? We'll get into it because, there's some grounds to have that conversation. There absolutely are. So we are going to absolutely go through this and go, as we do, talk through the documents, talk through what the court said. And that's it. That's all there is to it. Just get into it. All right. If you guys are asking questions, I am going to get to questions at the end. A few of you super chatted. Nate, the lawyer, says, I called it, baby. Yes, Nate was like, I don't think the personal jurisdiction is strong. He said that from the beginning. Dr. Riley said, question, is there no evidence order now? What happens to all collected evidence? Can KJ just delete away? I'll get to that at the end. And Creepshow said, I'm putting money down now and say, we'll see them refile in a week. Who's with me? I think this will be refiled rather quickly because there's not a lot to do to refile it. And we'll talk about that. We'll talk about what the court could have done, what the court did do, and what I think is coming up next. So let's break it down. I'm going to make this big so y'all can see it, so I can see it. I need computer glasses. I'm going to be real with y'all. Sometimes we just need computer glasses. All right, let's go. Oh, for those of you that are new here, hi. Do the YouTube things, the likey things, the subscribey things. Much appreciated. It's great to see almost 5,000 of you in here right now. All right, let's talk about it. Order granting defendant's motion to dismiss for lack of personal jurisdiction and denying defendant's motion for sanctions. That motion for sanctions that we have talked so much about, I had said last time, there is time here for Brown to reply. And the court was like, nope, no reply. I want to hear nothing more from any of you. No more. So let's go ahead and, wrong one. Let's go ahead and wrong one. Professionals here, people. This matter comes before the court on a motion to dismiss filed by defendants Katie Joy Paulson and Without a Crystal Ball LLC. On a motion for sanctions also filed by defendants. The motion to dismiss sets forth multiple grounds for dismissal, including lack of personal jurisdiction, lack of diversity jurisdiction. failure to join necessary parties, and failure to state a claim on which relief can be granted for some of the counts, not for all of the counts. But because the court got to no jurisdiction, yeet, and doesn't get to the rest of the questions. The motion for sanctions seeks an award of sanctions against plaintiff counsel Michael Saltz for alleged conduct related to defend the declaration of Lori Barnhart. You guys, jurisdictions decided. You know what that means? That means all the Lori Ann Barnhart stuff with regard to this case is irrelevant now. Done. Plaintiffs Tatiana Westbrook, James Westbrook, and Halo Beauty Partners opposed both motion. Having reviewed the parties' briefs in support of and in opposition to the motion and relevant exhibits and case laws, and the remainder of the record, the court grants defendants' motion to dismiss for lack of personal jurisdiction and denies defendants' motion for sanctions. The court's ruling is as follows. Do we love the 25-line paper? I know I do. Also, it's very succinct. We love a clear and succinct ruling. Plaintiff Tatiana Westbrook is a self-described internet personality, celebrity, and influencer who critiques beauty products and posts these critiques on social media platforms, including YouTube. See, these sites are to the complaint. So complaint, paragraph 10, which is going to be, these things. Number 1 is going to be the line. So paragraph 10, number 1, citing to the line. It's so helpful. That's why the lines need to match up. She claims to have over 9 million followers on YouTube alone. All the ids just cite back to where it came from. Plaintiff Halo Beauty Partners is a Nevada LLC, is a nutraceuticals company that produces products formulated to support hair, skin, and nail health. Ms. Westbrook founded and owns Halo with her husband, plaintiff James Westbrook. For purposes of this motion, the court takes as true the Westbrooks' claim that they are and were, at all relevant times, domiciled in King County, Washington, and we get a footnote. Let's get into a footnote. Let's see how sassy Babs's footnotes are. Or actually, research attorney extraordinaire, to be for sure. Both sides devote substantial effort to arguing whether the Westbrooks were at all relevant times domiciled in Washington. Even plaintiffs deny, however, that the plaintiff's domicile is relevant to the inquiry of whether personal jurisdiction exists over defendants. And furthermore, the court, as it must, for purposes of this motion, takes plaintiffs' allegations concerning their domicile as true. Plaintiffs' opposition at 11. Look, we've talked about this a lot. The fact that in a motion to dismiss, all the facts that the plaintiffs say are taken as true. We've talked about it. That was footnote 1. On point. No sass, but also judge. We don't expect a ton of judge sass, but we'll see. We'll see what we get. Defendant Katie Joy Paulson is a resident of Minnesota. Her company, Defendant Without a Crystal Ball, is a Minnesota LLC. Paulson is an internet, quote, blogger and vlogger who makes, produces, and uploads, quote, drama and or tea videos and internet posting on various internet-based platforms, including but not limited to YouTube and Twitter. Defendants have an estimated 135,000 YouTube followers. Id at 14. According to the complaint, starting in May 2019, defendants have uploaded to YouTube and Twitter dozens of videos targeting the Westbrooks and Halo, designed to, quote, ruin Miss Westbrook's, quote, good name and reputation. Remember, the good name and reputation goes directly to the heart of what defamation is. These videos are presented as, quote, exposés covering a range of subjects, including 1, a public dispute between Miss Westbrook and a rival beauty celebrity, James Charles. 2, the safety and efficacy of Halo vitamin products, which Paulson refers to as snake oil. 3, the personal business history of the Westbrooks, including alleged legal disputes and business failures. 4, a lawsuit filed in October 2020 in Los Angeles Superior Court by plaintiffs', quote, business partner Clark Swanson against Halo Beauty Inc., a company affiliated with plaintiffs. Plaintiffs claim that in these videos, defendants have, quote, intentionally harassed and maligned plaintiffs and or otherwise maliciously portrayed them in a false light. Remember, false light is part of this. There were false light allegations in this complaint, and sought to financially harm them. Defendants' videos have, quote, been published to and or are accessible to by the general public, end quote, and have been viewed, quote, hundreds of thousands, if not millions of times. These are all quoting back to the complaint. Plaintiffs have sued defendants for defamation, IIED, NIED, violations of the Washington Consumer Protection Act, among other courses of action, and seek $5 million in damages. See id. Plaintiffs cover sheet. They said up to $5 million. Okay, we're gonna just let it go with the $5 million of damages. Up to. But anyway. Defendants moved to dismiss plaintiff's claim under Federal Rule of Civil Procedure 12b-2 for lack of personal jurisdiction. Because the court grants defendants' motion to dismiss on these grounds, it does not reach defendants' remaining challenges to the complaint. So all of the other things argued are irrelevant. The court's like, no, we don't know her. We're ruling on personal jurisdiction, and with that, we are done. We're not getting into anything else. Discussion. This is going to be the law and the ruling. This is going to be what the court finds the law is, the facts that apply to the law, and why the court did what she decided to do. Discussion. General principles on a motion to dismiss for lack of jurisdiction. We're all going to know more than about personal jurisdiction than you've ever in your life wanted to know. Also, my video on my end looks barred on the sides. I have no idea why. I was recording the podcast yesterday and had to change some settings and didn't change them back. So that's probably just on me. Personal jurisdiction is one of the main tenets of law. You cannot rule over someone without having reason to have jurisdiction over them. So the court is going to get into their breakdown of what the law is and what she finds the facts to be with regard to that law. When a defendant moves to dismiss for lack of personal jurisdiction, quote, the plaintiffs bear the burden of demonstrating that jurisdiction is appropriate. And then these are cites to the case law that the court's relying on. All of the plaintiff's uncontroverted allegations are taken as true, and factual disputes are resolved in plaintiff's favor. How many times have you all seen me said that? Just let me know in the chat how many times we've talked about the factual issues going in favor of plaintiff. So many times. In the absence of applicable federal law, right? Because the case law with regard to jurisdiction is kind of a mess, and it's very difficult in the age of digital media and the internet. So we are for sure going to talk about that at the end of this when I give you kind of my thoughts on the whole thing. In the absence of applicable federal jurisdiction, federal law, jurisdiction is governed by the long-arm statute of the state in which the court sits. That's the statute where it says what jurisdiction is for that state. That's the long-arm statute. Washington's long-arm statute extends personal jurisdiction to the broadest reach of federal due process. And that is the RCW 4.28.185. And then shoot, not shroot. I always want to read it as shroot, but it's shoot versus Carnival Cruise Lines. To comply with the requirements of due process, a plaintiff must demonstrate, one, that a non-resident defendant has established minimum contacts in the form state, two, that the exercise of personal jurisdiction comports with traditional notions of fair play and substantial justice. Courts apply a three-part test to determine whether the non-resident defendant has the requisite minimum contacts. We've talked about minimum contacts so much with the form state for the exercise of specific jurisdiction to be appropriate. There are three parts, and we've talked about it. We've talked about the three parts. One, the defendant has purposely directed their activities. Now, all the case law says his. If I say their, it swaps in my brain. But purposely directed his, it's their activities towards the form. Two, the plaintiff's claim arises out of those activities. Three, the exercise of jurisdiction is reasonable. That's the Burger King case and the Schwarzenegger case. There's a footnote. International shoe. Like one of the OG cases, because, right, 1945, whenever we talk about jurisdiction, we talk about international shoe. The court's footnote says personal jurisdiction may be general or specific. General jurisdiction requires that the defendant's contacts in the form state are continuous and systematic. Because plaintiffs here do not claim that defendants are subject to this court's general jurisdiction, the court considers only the question of specific jurisdiction. And that's absolutely it, because There's no argument here that the contacts in the state were continuous and systematic. Continuous and systematic, on an easy example, would be like, oh, it's a national retail chain and they have employees there, a location there, they have regular contacts there. This is a specific content with regard to this case. So did the actions here create specific jurisdiction related to this event? End of the cite. Defendants challenged the first prong of the minimum contacts test and deny that they purposefully directed their activities towards Washington. And in all the commentary we've done, we've talked about this. Everybody who's talked about it, Nate's talked about it, Uncivil's talked about it, I've talked about it, Ricada's talked about it, all of us have talked, like, what's purposeful direction? Is it enough? For me, I'm like, look, some of the research and some of the reaching in feels like a lot, but we'll see what the court says. Others were like, no, I don't want it to be, no. And there's reason for that, because when we engage in the internet, what you don't want is people to be able to be pulled all over the country based on posting on YouTube. And that's kind of the bigger underlying conversation here. But before that, we're going to get to the court's ruling. Whether defendants' actions were purposefully directed at Washington state, the effects test under Calder and subsequent cases. We've talked about this in every motion where we actually talked about jurisdiction before the train went, off of the rails down a ravine and caught on fire. Once the train caught on fire, we didn't talk about jurisdiction for a while, but we're back to talking about like actual jurisdiction. The Ninth Circuit has recently acknowledged the difficulty of analyzing personal jurisdiction in the contents of internet-based claims, and this is going to continue to happen. We saw this in the Keem case, and I'll talk about the Keem case a little bit at the end of this. When an individual in one state can cause serious harm anywhere in the world without leaving the comfort of their home, and this is that Janice or Janu case out of the Ninth Circuit in 2020. Courts have sought to strike a fair balance between the interests of defendants who may have no intentional connection with a form and plaintiffs who may nevertheless experience harm, all while maintaining a principled approach to the concept of jurisdiction rooted in due process. Even in this context of constantly and rapidly evolving technology, whether a defendant accused of an international tort such as defamation has purposefully directed its activities towards a form sufficient to establish personal jurisdiction is still governed by the effects test outlined nearly 40 years ago by Calder. So trying to take 40-year-old case law and trying to say, how does this fit? How does this fit with what's going on now? Under this test, courts are to determine whether the defendant, one, committed an intentional act. Here, I still think there's no question of that. Words were spoken. Two, expressly aimed at the form state. That's where we've all talked about there being issue. And three, causing harm that the defendant knows is likely to be suffered in the form state. Also, not an issue because it was known, I think, clearly that Tati lived in Washington. Apparently conceding prongs 1 and 3, defendants claim that plaintiffs failed to establish the second element of the Calder effects test. I love that the court's like, apparently, because it's not clear. And it wasn't clear. Nothing in that motion to dismiss was clear at all. The defendant's conduct was expressly aimed at Washington. Footnote 3. It is not clear from case law what distinction, if any, is intended between the phrases purposefully directed and expressly aimed. But for the purposes of this case, because defendants have not challenged the first and third prongs of the effects test, the effects test effectively collapses into the first prong of the minimum contacts test. So the court is just saying, look, there is this difference in language in the case law, purposefully directed and expressly aimed. And we can nerd on that another time, but the court has said this is not the time because defendants aren't challenging those things. We're just defaulting to this first prong of the minimum contacts test. Anyone who's been through law school now probably wants to vomit because it's like, oh my God, we've done that. Like, Why are we reliving law school? I know, but the court's breaking down for anyone interested in how these are applied. The court's broken out the test well and cleanly. It's what I love about reading rulings. In the Haley Page case, when we were reading through it, it's like it's this and then it's this and then it's this. It's very clean and clear to read. So we're talking about this being the purposefully directed test, committed an intentional act, expressly aimed, causing harm. We're looking at expressly aimed at the form state. Was enough done aimed at Washington to make it fit? And then when the court says it defaults to the first prong of the Calder test, it's this: the defendant has purposely directed their activities towards the form. Were the actions done directed at Washington specifically, or were they just kind of broad and smashed all over the place? Which, YouTube. The thing is, well, let's see what the court says. That's the first prong that we're looking at. In Calder, Shirley Jones, a California television and movie actress, brought a libel suit in California state court against a reporter and editor based on an article published by the National Enquirer, headquartered in Florida. In concluding that defendants had expressly aimed their conduct at California, the court noted the following factors were significant. The defendants had reached out directly by telephone to sources in California. And this is one of the prongs I was like, do we have that? This is one of the prongs why you saw Salty filing the Lorianne Declaration and stuff, were people specifically reached out to. So that goes to that prong of the test. So you can start to see why things were done, because now we have the court's ruling and we can look back and be like, this is what was done. And I totally lost my place because of course I did. The court noted the following factors. Okay. Had reached out directly by telephone to sources in California, that the article concerned the California activities of a California resident and contained various facts that gave the article a California focus. The National Enquirer sold 600,000 copies of the article in California. And I'm curious to see if the number figures into the court's ruling, because 600,000 is a lot of copies. Out of the total nationwide circulation of 5 million, almost twice as many as in the next highest state. So 600,000 in California was like more than any other state, more than double any other state. So they did the most in California. And that the contents of the article were alleged to have caused injury to the plaintiff's reputation in the estimation of the California public, and specifically impugned the professionalism of an entertainer whose television career was centered in California. Since Calder, courts have weighed similar factors connecting a defendant with the form, tempered by a recent admonition in Walden versus Fiore. In that case, a unanimous Supreme Court expressly rejected the view that Calder's effects test is satisfied merely by the defendant's commission of an intentional tort that is aimed at a person known to be a resident of the form. So there has to be more than just saying, I know I'm doing the thing and I know that you live there. There has to be more than those two things. Mere injury to a form resident is not significant contact with the form. The Walden court noted that the proper question is not where the plaintiff experienced a particular injury or effect, but whether the defendant's conduct connects him to the form in a meaning way. Does the action connect you to that state? As noticed above, in the context of internet-based conduct in particular, courts, quote, have struggled with the question whether tortious conduct on a nationally accessible website is expressly aimed at any or all of the forms in which the website can be viewed, and have required something more than maintenance of a passive website available anywhere with an internet connection. The Ninth Circuit has found jurisdiction where a defendant continuously and deliberately exploited the form state market for its website, and a substantial number of hits to the website came from the form. Maverick's photo, it has declined to exercise jurisdiction, however, even where almost 20% of defendants' total circulation was located in the form. And that's where those numbers become significant. So the court said 20% is not enough in that case, where plaintiffs did not establish that defendant expressly aimed at the forum or tailored the website to attract forum-specific traffic. And that's where you saw defense saying there's no contacts, there's only this percentage of viewers, there's not enough viewers. And you saw Saltz arguing, yes, but because you're talking about a Washington YouTuber, it's going to draw a Washington audience. Whether defendant's suit related conduct was expressly aimed at Washington. And the court's getting into the cases now in this particular area. The case demonstrate that the ultimate question of when defendants expressly aim their suit-related conduct at a forum state is intensely fact-specific. So the court has to look at each case. Now, the court can, I will say, that they didn't in this case. The court dismissed it. But the court can say, okay, we're going to do discovery on this issue and see how many contacts we have with the forum state. And the court chose not to do that here. Could that be because Babs was already fucking done? Totally possible. And I'm sure you'll have questions about that, and we will talk about it. One clear import of the Ninth Circuit case law express aiming is that the district's court's inquiry on this score must be grounded squarely on the facts of the particular case. After examining defendant's connection to the state of Washington, the court concludes that defendant's contacts in this case are the kind of, quote, random, fortuitous, and attenuated contacts with the forum state that Walden cautioned courts against relying on. So the court is saying, look, the subscribers, the members, Lorianne, it's not enough. They are random and fortuitous. They just happened. They're attenuated. It's a reach. So it's not enough. The connections alleged include sources for the content. Plaintiffs allege that defendants searched through and relied upon Washington sources for their information. The evidence demonstrates, however, that Paulson conducted several different searches using general internet search engines, looking all over the place, everywhere. Declaration of Tati Westbrook. Quoting May 31st, 2019 video, Paulson did a, quote, a regular, very basic background check, and also noted, quote, you can actually go state to state to try to pull up some stuff as well. Plaintiffs argue that Paulson must have used Washington-specific websites in her research, a reasonable inference from the content of her videos. However, it is also clear that she likely used state-specific websites from multiple other states as well, so not just from Washington, citing the June 2nd, 2019 video. Paulson stating all of this information came from court records from Hawaii, California, South Carolina, North Carolina, Washington State, and Georgia. All of this is public record. Unlike in Calder, there's no allegation that defendants reached out directly or indirectly to any resident of Washington for information for the videos. Plaintiffs' claim that defendants relied on Washington sources is significantly overstated. So the court, Babs is saying it's a reach. It's a reach. It's overstated because there are Washington sources, but there are also sources in Georgia, North Carolina, South Carolina, California, and Hawaii. So it's not just Washington. Focus on plaintiffs' activities in the forum. Also, unlike the article in Calder, which was focused on Jones's activities in the forum, defendant's video did not refer to any substantive way to activities conducted in Washington. Plaintiffs' proffered examples of defendants referring to Washington are brief, isolated, and incidental. So talking about Tati, but not talking about like shit Tati specifically did in Washington. Tati grew up in Washington, and her mother actually was her talent agent. Tati and her family moved around a lot. Other than a brief reference Paulson makes to Ms. Westbrook's small tax warrant in 2003 in Washington, lasting mere seconds of hours and hours of video at issue, the court was unable to identify any explicit references to Washington that might arguably impugn the Westbrook's reputation. Critically, almost none of the few Washington reference in defendants' videos are connected to the underlying defamation claims in this case. So the shit that was said about Washington is not the shit that is alleged to be defamatory. Instead, the majority of defendants' alleged offending content concerns events and subjects, such as Ms. Westbrook's feud with James Charles, The court is talking about "Bye, sister, and I live," such as Westbrook's feud with James Charles and the Los Angeles lawsuit Clark Swanson filed against Halo that took place in California or virtually online. Defendants' discussion of plaintiff's vitamin products is directed at plaintiff Halo, a Nevada company, and none of Miss Westbrook's YouTube videos, the frequent topic of defendants' videos, were apparently filmed in Washington or even concerns activities that took place in Washington. This is in contrast to the situation in Calder, where the court reviewed, quote, "the various factors that gave the article in a California focus," and concluded California is the focal point of the story. So the court is really saying Tati Westbrook is the focal point of the story. Tati Westbrook being from Washington is irrelevant to that story because Tati's the focus of the story. And a lot of the videos were filmed not in Washington. And I think that it makes sense. It makes sense. Look, reaching out to another state to pull a defendant in, this is courts setting the line of how much is enough, how much is not enough. And the courts lean towards not having jurisdiction, not towards having jurisdiction. So whether the research was done there, the court's saying, yes, it was done here, but also here, which is fair. Activities directed at large number of citizens in the forum. Well, we all have had issues with the large numbers in the conversation with this. Calder and its more recent progeny also indicate that a plaintiff must demonstrate that the offending content both reached a large number of forum state residents and was intentionally targeted at the forum. In Calder, the reputation-based effects would not have occurred but for the fact that defendants wrote the article for publication in California that was read by a large number of California citizens, right? Because no internet when Calder was written. No widespread internet was the begin. No, Calder was well before the internet. And I lost my place talking about the internet. Okay. Finding specific jurisdiction appropriate in state where substantial numbers of copies, 10,000 to 15,000 per month, are regularly sold and distributed. As more recent cases dealing with internet-based injury establish, it is not enough that a defendant's content is merely accessible to residents of the forum. Not all material placed on the internet is, solely by virtue of its universal accessibility, expressly aimed at every state to which it's accessed, which is a good thing for creators everywhere. Where the plaintiff does not identify any evidence that defendant specifically targets or solicits forum state viewers, the forum state residents' ability to view defendant's online content alone is not enough to demonstrate express aiming. Plaintiff does not present any evidence to show defendant's website. This is referring to a case it cited. Does not present any evidence to show defendant's website had a specific focus on California or has a substantial California user base. Plaintiff proffers no evidence to show defendant posts and profits from California-specific advertisements on its website. Furthermore, the online stock and commodities trading market cannot be reasonably considered a California-centered industry, unlike a celebrity gossip industry in Mavericks Photo Inc., which arguably revolves around Hollywood, California. The court takes as true plaintiff's bare bones claim. The court does not like that there's not more evidence with regard to the viewership in Washington, but there couldn't be more evidence because there hasn't been, discovery yet. The court takes as true plaintiff's bare bones claim that defendant's viewership includes residents of Washington, but that factor alone is insufficient to support their bid for jurisdiction. Plaintiff's opposition at 4. In support of their claim that jurisdiction lies in Washington, plaintiffs have submitted 1, the declaration of 2 Washington residents who viewed defendants' videos and based thereon did not buy plaintiffs' products. 2, the declaration of there it is. We found it. We have found it. The court is referencing the Lori-Ann Declaration. 2, the declaration of one of defendants' quote fiercest and loyalist fans. I really hope that when the research attorney was writing this, they were not going to just write the Lori-Ann Declaration. I love that they actually went in to break down this declaration. A Washington resident who subscribed to defendant's YouTube channel during the time period that Ms. Paulson published numerous videos and other content maligning plaintiffs in this case. See declarations, and then the Macy Declaration, the Hope Walker Declaration, the Kilm-Fulmer Declaration, and the Declaration of Lori Ann. Even crediting the testimony of these three witnesses, the declaration of three viewers in Washington out of alleged hundreds of thousands, if not millions of times that defendants' videos have been viewed, only highlight the vast discrepancy between this case and the 600,000 California readers in Calder. Again, quoting Maverick's photo, jurisdiction existed because substantial number of hits to defendant's website came from California residents. Again, that's where sometimes you will see the court grant jurisdiction instead of dismissing, but I'll talk about that at the end because the court can be like, okay, let's see how many it really is. I think the court was just like, oh, it's not a lot. Yote, y'all gone. It's not enough. Goodbye. So instead of even fucking with discovery, the court was like, get out, just get out, just get out. Get out. The court lacked jurisdiction, even though 20% of defendants' audience lived in the forum state. Significantly, plaintiffs have proffered no allegations of, for example, Washington-specific marketing or advertising. And I don't think in this case there is any, from which one could conclude defendants targeted Washington as opposed to a wider audience. Generally, the court finds that plaintiffs have failed to demonstrate that defendants expressly aimed their video content at Washington and thus have not shown defendants purposefully directed their actions towards the state of Washington. Therefore, the court concludes that Washington is the improper form. You don't go here, and I am not the boss of you. Goodbye. And this court lacks personal jurisdiction over defendants' motion for sanctions. So that is the end of you don't go here. I'm not the boss of you. Goodbye. Go elsewhere. Bring this case in another form. Goodbye. 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 Defendant's motion for sanctions. So the court just shut this down. Now, there was still time to reply to this, but I think the court was like, we're done. We're done. We're done. Just get out. Which is why, if you'll remember, in Brown's motion to shorten time, the motion that can't be brought in Washington but was brought anyway, that motion to shorten time, part of Brown's argument was this court could yeet jurisdiction and you'll never let me file my Rule 11 motion, so can you please shorten time? And that's actually exactly what happened here, is that the court did not shorten time and yeeted jurisdiction before he could bring that Rule 11 motion because it's still in the waiting period. Defendants have filed a motion seeking sanctions against plaintiff's counsel Michael Saltz, essentially accusing him of harassing and intimidating third-party witness Lori Ann Barnhart, and of both sojourning and committing, I can never pronounce this, sojourning, encouraging and committing perjury. Motion for sanctions, docket number 59. Defendants rely on 28 U.S.C. 1927, which provides that the court may order any attorney or other person admitted to conduct cases who so multiplies the proceedings. I have feelings about who's multiplying the proceedings. In any case, unreasonably and vexatiously. Always love the word vexatious. To satisfy personally the excess cost, expense, and attorney's fees reasonably incurred because of such conduct. Again, multiplying the proceedings. Okay. Where ordered, these sanctions must be accompanied by a finding that the sanctioned attorney acted recklessly or in bad faith or committed intentional misconduct. And then it defines bad faith, which is defined in all of those motions that we've read. The court declines to rule on defendant's motion for sanctions for several reasons. First, the misconduct alleged is serious and, if proven, could expose Saltz to sanctions up to and including disbarment. Given the gravity of the potential consequences, and because defendant's allegations are both convoluted and avidly disputed, the court actually said convoluted. The court could not rule on the motion without an extensive evidentiary hearing. Holy shit. Babs is like, you know what I'm not doing? What I'm not doing is fucking with either of you. I am not messing with this. Because yes, There would need to be an extensive evidentiary hearing. Babs is not wrong. And yes, the allegations are serious. And yes, I think those allegations go both ways. And I think that the court was like, oh, these allegations go both ways. Furthermore, because the Barnhart Declaration is not material to the court's ruling on jurisdiction, the integrity of these proceedings is not impacted to the extent that, that defendants contend. And while the court acknowledges it has the discretion to rule on the motion, the fact that this case is being dismissed means the court's supervision of these proceedings is no longer required. I'm out, bitches. Literally, judge speak for, I am out. Babs has left the building. No, I am not dealing with any of you. That's what that says. Which plays into kind of my thoughts of this in whole. And while the court acknowledges it has the discretion, like I could if I wanted to rule on the motion, the fact that this case is being dismissed means the court's supervision of these proceedings is no longer required. Get out, everyone. In sum, the court declines to devote its resources to investigating the activities of a California attorney not licensed in Washington in a case that's being dismissed. The motion for sanctions is therefore denied without prejudice, which means, again, it can be brought again. Conclusion: for the foregoing reason, the court grants defendant's motion to dismiss. Defendant's motion for sanction is denied without prejudice. This case is dismissed without prejudice. What dismissed without prejudice means is you can file this shit somewhere else, but I don't think there's enough to file it here. So get out. And that is a very succinct 13 pages of Babs saying no. And I think at the end, we get insight into how Babs is feeling about this case, because she does say the court declines to devote its resources to investigating the activities of a California attorney, Salt, not licensed in Washington, in a case that's being dismissed. I don't want to deal with you at all. I'm out. You're out. We're out. And that's it. So the court dismissed the case, meaning you can't go here, go to another jurisdiction, and denied the sanctions motion, which means it can be brought again. Now, let's get to your questions because I know you have them. No, my thoughts first. Thoughts, and then questions. My thoughts. We have talked a lot about jurisdiction, though not lately, in this case. And there were always two thoughts on jurisdiction in this case. Did KJ do enough aimed at Washington to have personal jurisdiction or not? And that was really always the question. And the stuff with Lori Ann became the most difficult, I thought, with regard to personal jurisdiction. Babs said, no, you're not interviewing people, so it doesn't matter if you have a ride or die there. Wasn't taking the agency argument, didn't even bring it up because it was brought up in a precipice. It was not brought up in the original motions. What courts will normally do with this, and what I've seen courts do in this, is that they will grant discovery to the issue. Babs did not grant discovery to get into the jurisdiction, because a lot of times they'll be like, I am not seeing it, but we need discovery to see how much happened in Washington, because there is how many subs. Let's get the back end analytics. Let's look at it. The court didn't do that. The court said GFO. Out. Get out. Oh God, get out of my court. Get out. So to me, the court not granting discovery with regard to jurisdiction shows that the court is not inclined to invest the resources it would take to deal with these two attorneys fighting back and forth. I don't think she wanted to do, she said it, I'm not devoting the resources to answer these questions about sanctions. I don't want to do it. No. So a lot of you asked me over and over, could the strategy of Brown filing all these motions just be to annoy the judge so that she gets rid of jurisdiction? And I've always said, I mean, it could be. anything's possible. Will it work? The judge is going to rule on the law, but the facts on the law in this case was never clear. It was always going to be interesting to see, and I've always said it's going to be interesting to see what the court does on jurisdiction. Now, we see, again, litigation tactics coming into play here, like we saw in the Keemstar case. In the Keemstar case, I think there was no jurisdiction where it was filed. It was filed in California. Keem's in New York. But the law was better for Keem and his defense in California. So instead of fighting with jurisdiction, they said, fuck it, let's ride, and had the case dismissed in under a year. So it'll be interesting to see if and when this is refiled in Minnesota, because that's where it's going to be refiled. If it's refiled, I can't imagine it's not. I'll tell you what I think is happening today over in the Westbrook camp, based on my speculation, monuments to the gods of. But we will see if the play to get jurisdiction bounced out of Washington pays off, because if the law in Minnesota is not as favorable to KJ, it's, you win the battle, but what's next? I think it will absolutely be refiled in Minnesota. I think we'll see it refiled pretty quickly. Why do I think it'll be refiled quickly? Because this has always been a possibility. At some point at the beginning of this litigation, Saltz and his co-counsels would have sat down with their clients. Or should have. I don't know. Not in the room, not involved. What should happen is that you sit down and say, this is the law in Washington. This is the law in Minnesota. We can file here. Pros, cons of this, pros, cons of this. What do you want to do? Because at the end of the day, those are presenting decisions and letting the client decide. Do we want to bring them into, Washington? Do we want to go to Minnesota? If we bring them into Washington, this is what can happen. If we just go to Minnesota, this is what can happen. What do we want to do? And that becomes a strategy as well, where you file, because the plaintiff can file anywhere the fuck they want to file. There just has to be jurisdiction for the defendant there. So could the strategy of Brown been, I think that the facts go on our side with regard to personal jurisdiction, but factual determinations go both ways, and the court can rule either way. So do we heighten this litigation to the point where the court is just like, I'm not dealing with, what I'm not doing is going back and forth and dealing with any of you. So file hundreds of pages of shit. I'm not dealing with it. Could that have been a tactic? Sure, it could have. Because anything's possible. Because the court didn't grant discovery. The court said, get out. So do I think the court's annoyed as fuck with these two parties? Yep. And the court has an option to pull the escape hatch. The court vented out of this case. Like 100%. So done. Done. Which is interesting. The court didn't want to hear discovery. The court didn't even want to fuck with it. And that's why I think that the court's already around. The court's already annoyed with these parties, because instead of granting discovery, the court just vented. The court was out. Absolutely out. Which, how annoyed are all of you with all the motions that have happened? Like, we're all curious and we're all just like, oh God, not another one at the same time. So could that have been the tactic? Yes. Here's the thing though, in going to Minnesota, which is where I think that the Westbrooks will refile, there's really no purpose for them to file in California. Could they choose to and try to argue there? Maybe. I can't imagine that would be the case. I think they would choose to go to Minnesota, because then there's no jurisdiction argument at all. And if they go to Minnesota, they open a few interesting doors for them as well. Yes, it's more convenient to KJ to be in Minnesota. If they're going to do, depositions and what have you, they're going to be, well, some of them will be there, some of them might not, but you lose some of those objections to discovery and things like, oh, well, it's onerous to produce because we're being dragged into a different form. You lose some of those tactical objections. I don't know how much that will matter with regard to discovery. A lot of this is digital, but when it goes to showing up for depositions, you can't really object that it's too onerous on you because it's in your form state. So there's that. Also, Minnesota, because I looked at this at the beginning of like, okay, be careful what you wish for. KJ's asking for this case to go to Minnesota. What does it look like in Minnesota? Minnesota has some pretty strong cyber harassment laws. So does this case change a bit from a defamation case to a cyber harassment case? I mean, it could. It absolutely could. We'll have to see what they file because there's different things that they can file in different states. But Minnesota has some strong cyber harassment laws. Those don't have like this public figure analysis where you have to show maliciousness, where you have to show some of these other factors with regard to defamation. I also think that Minnesota's defamation suit is neutral. It's not particularly difficult to prove defamation more so than another jurisdiction. Look, defamation, with a public figure, you have to show malice and you have to show damages. I think we've seen indication of damages with some of these declarations that were filed in this suit. What we'll see with regard to malice, we'll see what happens with that. But there's still no like anti-SLAPP laws or anything like that in Minnesota. So the case doesn't get like, oh my God, if we go to Minnesota, it's this much better. With regard to the to things like statute of limitations, I don't think there's a huge play with statute of limitations between Washington and Minnesota. Statute of limitation means that, you only have so much time to bring the case. It'll be interesting to see if they go harder towards harassment or cyber harassment than towards defamation if and when this is refiled. And I say if and when, because I think it will be refiled in Minnesota. I don't see the Westbrooks letting this go. Both sides are now out. All of the money of litigation here, the prologue has ended and it starts over again. So when will we see that? I don't know. What would need to be done from that? Well, we saw that Saltz filed the original complaint. So they will take that complaint and retool it for Minnesota law to allege the things that they can allege in Minnesota. You can actually get punitive damages for some of this stuff in Minnesota, which are like the punishment damages, which you can't get in Washington. So that's an interesting quirk to this. I think it raises the threshold of loss in this case, but I don't know if that's something defense cares about all that much. I think the early win is definitely where they were focused. But again, be careful what you wish for, because if the Westbrooks go to Minnesota and are successful on cyber harassment, not saying they will be or won't be, if they are successful, could that open up others or induce others to file similar types of cases using similar types of law? Maybe. Will they still have diversity jurisdiction in Minnesota to file in federal court? Yes, you still have a Nevada company, Washington residents, and then Minnesota parties. So yes, you're still going to have it there. Other thoughts on this? I mean, at the end of the day, when we are talking about what's best for content creators, what's best for content creators as a whole is that it's harder to prove personal jurisdiction, not where you live, right? We talk on the internet, somebody might be offended somewhere else and be like, I'm going to sue you where I live. What you don't want to see is the courts allowing people to be dragged all over the place with regards to jurisdiction. Do I think that KJ, does the most with regard to the things I've seen play out in this case? Yes. Is that enough for personal jurisdiction? The court said no. Do I think there was room for the court to say, fine, I think there's enough to ask the question. Let's look at the analytics and order discovery with regard to jurisdiction. I think the court absolutely could have done that here. Do I think the court looked at everything that's happened in this case and go, I am not touching that with a cattle prod? Absolutely. Absolutely, I do. And I think the court's own words here indicate that. I am not using the court's resources and extensive evidentiary hearings to fuck with all of you. I am not doing it. So this is essentially dismissed without prejudice, which means it can be refiled under the laws of another state. If I were the Westbrooks, I would refile it in Minnesota. If I were the defense in this case, I would hope that there is a legal strategy as to why they believe that the Minnesota case law is better for them. Because if they wanted to pull it home, there needs to be a reason for that, because we're just at the end of the prologue. We're not at the end of the book. We're not at the end of the chapter. We're at the end of the prologue, because I just don't see the Westbrooks letting this go. What happens with Salty? Well, Salty was pro hoc vice in Washington, and I imagine will just be pro hoc vice in Minnesota, and they will hire a Minnesota law firm, which is probably what they're doing, today. They will hire local counsel in Minnesota. KJ will have to hire a new attorney in Minnesota if this is refiled there. I don't think Brown will appear pro hoc vice in Minnesota, because why would you have Brown still appear and pay a Minnesota lawyer and a Washington lawyer? I can understand why for Tati, it seems that Saltz has been her attorney, dealt with this for 18 months and has such a knowledge of the case because dealt with all the cease and desist, that is your kind of quarterback calling the shots. And then local counsel is, your players on the field making sure shit's done properly per the local rules. So I think this is the end of the prologue. We probably won't see Brown again in this case. We will probably see it refiled. What's the over under on that? I don't know. Could it be a week? Could it be 3 weeks? Could it be a month? Sure. I would imagine they would want to do it sooner rather than later, because again, there's still that you're on notice of litigation, so don't delete your shit. That still exists. There's still a notice of that. Could there still be fallout from what happened in Washington? Yes. If they get into discovery in this case and find that there was substantially more subscribers in Washington than were portrayed to the court in declarations, could that still be a problem? Yes. Could the stuff Brown filed with regard to Lori Ann still be a problem for Brown? Yes, but that will come outside of this case if Lori Ann chooses to go out. Lori Ann might just want to be fucking done. Lori Ann is probably like, oh, thank God. Thank God this is done. I am out. Can I be out? Because she's only really relevant to jurisdiction and now relevant to, what Brown might have created or what problems there might be there. If, Brown tries to go after Salt more for this in other venues, tries to make complaints against him, could that still happen? Yes. This is not the end by any means. This is the end of the prologue of the saga that is the Tati Westbrook without a crystal ball defamation case. And a lot of litigation funds have been spent to move this into another state. Was that the intent of the Westbrooks? Hey, we're going to file it in Washington. If they concede to jurisdiction, we like the law here and we don't have to go everywhere. If they don't concede jurisdiction here, they're going to waste funds. We think we can outspend them. So we're going to see what they choose to do and then take it to Minnesota anyway. Could be. I mean, litigation strategy is going to be between the parties and the lawyers. And I want to go ahead and answer your questions. So everybody, can we just take a moment and say jurisdiction has been ruled on? Jurisdiction has been ruled on, because the law nerds, we don't really have a horse in this race. We want to see, what we want to see is good lawyering, see what happens, and see what the law says. And that's what we've seen. The court's like, I don't think it's enough, and get the fuck out of here with all of you. Get out. All of you, get out. Let's answer questions. The moderators have let me know that we have a lot of creators in the chat. If you are still here, hello, Adam. Hello, Sloan. Hello, Creepshow. Hello, Nate. I believe Uncivil was here too. Hello, hello, hello. Good to see everybody. And 7,700 law nerds. I should ask you to do the YouTubey things. Like, I always forget, and I appreciate you so much because you remember. But I don't know how many thumbs up we're at. Tell me how many thumbs up we're at. Go ahead and like the video. If you're not subscribed and you like the content, go ahead and subscribe. But jurisdiction has been ruled on. We have a ruling. We have a ruling. Oh, and go ahead and put question before what you say. What you say? Okay, stop. My kids are home for spring break, and that is one of their favorite little meme things with the what you say. Half-hearted joke question. If Tati refiles in Minnesota, what are the odds that Rekieta will represent KJ? I'm going to go with 0%, but Rekieta is going to be like, damn it. I am the Minnesota law guy, and I'm going to have to talk about this. Yes, Rekieta, you are. I want Rekieta's breakdown on cyber harassment in Minnesota and defamation in Minnesota. We need it. Question, didn't seem like KJ was angling for it being in California in regards to arguments for the motion to dismiss. The thing is, the defense is not in control of where it gets filed. All the defense can really do is say, but not here. Not here. Like, you want to file it here, but not here. But the defense can't say, but you have to file it there. They can only say, but not here. And but not here is what they've said with their motion to dismiss. Okay, fine. You want to file it in Washington? Nope, that ain't it. Not here. So now plaintiff gets to choose where to refile it. I imagine they will just, could they file it in California? I don't know why they would. Like, California has stronger SLAPP and anti-SLAPP statutes, and it's harder to prove defamation in California. So there's a reason that Johnny Depp filed his case against Amber Heard in Virginia and not in California. The plaintiff gets to choose the form. As long as there's a connection to the form for the defendant, the plaintiff can choose where they want to go. Tactically, California wouldn't be it. Would California perhaps be best for KJ? Absolutely. Is that one of the reasons California will not be chosen by plaintiff? Absolutely. Question, will this case progress faster now that jurisdiction is not an issue if they refile in Minnesota? There are still time limits. So what we will see happen, I suspect, if it's refiled in Minnesota, you'll see them file a complaint. And then hopefully you will see either a motion to dismiss on the merits, like that 12B6, hey, we're moving to dismiss the defamation, or an answer saying, like in the Shia LaBeouf case, hey, broad denials, go to discovery. So we can see those things. We can also see it settle. I don't think it's going to happen. But when we talk about all the possibilities, those are all the possibilities. So could we see them attempt to settle? I don't think so. I don't think that's going to happen. But could it happen? Yes, they could always reach a settlement. Look, these parties are so locked horns. I just don't see it. Question, is this a win for independent content creators because having an audience in a state doesn't mean anything to the court in jurisdiction? God, I can't phrase questions. Lemmy Z, you phrased that brilliantly. And I think, again, we've seen the court stand on, you have to do more. Like, it has to be more for there to be jurisdiction, and this isn't it. Would it have been interesting to see the court say, let's actually look at what it is? Sure, the court could have done that. The court was not about to do that in this case, clearly based on their writing, and that's okay too. But yes, for content creators, what you don't want if you have a website or a YouTube channel or anything is that, what you say can be seen by anyone anywhere. You want the courts to say, okay, but you have to do the most to be subject to jurisdiction here because you're sitting in your home making content. You don't want people dragging you all over the country. Do I think personally that KJ goes above and beyond what a lot of commentary channels do? Absolutely. The court said, right, but even 20% wasn't enough. And even this wasn't enough, which is why the Lori-Ann Declaration became such a matter of contention, because having a agent in the state, having a presence in the state is different than just directing content at the state. This is exactly what it is. Schmitty said, you don't have to go home, but you can't stay here. That is a perfect summary of that ruling. You don't have to go home, but you can't stay here. Annie J says, question, do you think the lack of synergy between the lawyers when it comes to negotiating about the jurisdiction played a role? Gosh, I don't even know why it popped off so hot, but it sure did. Salty did come out swinging a little bit because he made a bad faith crack about the Zillow posting. And a lot went down on social media. KJ was taking shots at Saltz. Saltz was talking about the case, but not talking about the case, was asking for people's commentary, and then the anti-KJ community kind of took it under there, which, I don't think Saltz did anything out of line, but I can also see where people are like, but it's right on the line. So there was a lot that went on early in this case that led to that motion to not delete your shit, and then the stipulation with regard to not deleting your shit. But the lack of synergy definitely jurisdiction is not something you're going to negotiate and concede because it does need to be proven at trial. So jurisdiction's not just, if there's an issue with jurisdiction, there's an issue. And the defense can either say, yes, there's an issue, but we're ignoring it, which is what happened in the Keem case. So Romeo Lacoste sued Keemstar. I've talked about it a bit after Keem won, and I will do a breakdown of that case because I keep referring back to it. Keem's lawyers could have fought jurisdiction and gotten the case moved. It didn't seem that there was any jurisdiction in California. It seemed much weaker than even this. But his lawyer said, we don't care. We're just going to win it here. The law's better for us here. And the defense can choose to do that. You can submit yourself to jurisdiction. And that's what happened in the Keem case. So, did Keem come in as I was talking about his case and his lawyers? I do not think they will refile in Minnesota. Keem, I think they will refile in Minnesota. So we'll see. We'll talk about it. We'll see how long as you come in as I'm talking about your case. Because Keem's had a very strong case in his case against Romeo Lacoste to move jurisdiction, but the law was better in California. And so they just knocked it out there. Keem won and got the play button. And I've talked about that a couple times. I think they'll refile, but we'll see. Keem, we'll see. We'll see what happens, won't we? We'll see if it gets refiled or not. So all of the restrictions lifted now. I wouldn't go ahead and say that. I'm sure that's a conversation that KJ's having with her attorney, but there's still notice that litigation could be pending. And I would imagine if there's an intent to refile, that at some point Saltz will reach out to her attorneys and say, this is being refiled, you're on notice, or sending a letter, you're on notice, because the duty to preserve doesn't just die when there's a notice of pending litigation. So that notice, I think that notice still stands, but we've already seen them have to go to court over that. Question, what happens when the culprits that hacked and sent death threats get caught? Now that the lawsuit's dismissed in Washington, do the lawyers have to refile all the motions and sealed documents? Heather, those are two questions, great questions. So the FBI is involved with regard to the hacking and the death threats and all of that stuff, and that can go down a criminal avenue versus a civil avenue, depending on a lot of factors. But the FBI is involved in that part of it. Now that the lawsuit's dismissed in Washington, it's clean slate. So it starts all over again in Minnesota. And that'll start, if they refile, with a complaint being refiled there. So I want Nick Rekieta to tell us all about the laws in Minnesota. Kimberly Roth, glad you came over from Instagram. If you guys don't follow me there, it's just at the Emily D. Baker. So pending litigation, we'll see. And I'm sure if they are intending to refile, that they will let the other side know that. And then we will all find out when it gets refiled, because we going to be checking Pacer because now we're all curious. Can you explain in more detail why jurisdiction in Minnesota would be given? Because it's where KJ and her business live. So personal jurisdiction, you can have personal jurisdiction over where your butt sits. In this case, they were trying to say, okay, you Minnesota business, you Minnesota person, you have to come to Washington and defend yourself because of what you did. You have to defend yourself here. Now, the court said very clearly, you cannot just drag somebody into court in Washington. And we went through all those prongs of the test saying, okay, but you have to have enough context. You have to avail yourself of authority of the court. It's like, I'm living in Middle Tennessee. California CHP can't just be like, oh, we want to do this thing here because I'm not there. So there has to be a reason you can have jurisdiction over someone, and them living there is about as easy a reason as you get. Why not California? The laws are not nearly as strong for Tati Westbrook in California, and there are more, I think, defenses available to KJ in California. So I don't think, would choose to go there again, like Johnny Depp choosing, not Johnny. Yes, Johnny Depp. Am I referencing the right case? Yes. Like Johnny Depp, though he and Amber Heard live in California, he chose to file that defamation case in Virginia. And that case has been through jurisdictional arguments too. So yeah. Question, how quickly can they refile? I mean, it really just depends on it depends on a lot of things. How quickly could they refile? I mean, if they wanted to refile today, nothing stops them from doing that. But it depends on if they prepared early in this case. Because look, what we know about this case is this case has gone on for 18 months before we got to here. There were multiple cease and desists. We know that. So did this litigation team prepare kind of a draft for if it looks like this if we go to Washington, it looks like this if we go to Minnesota? Possibly. If that was done, it's going to shorten the time for them filing in Minnesota. Would they probably look at procuring local counsel before they file? Yes. Does that take some time? It depends if they already have someone in mind or not. So there's a lot of factors that go into this. And this is also, again, the client's decision. So at some point, the litigation team will get on the phone with their clients and be like, okay, this is what this case looks like in Minnesota. Are we riding? And it will be the Westbrook and Halo Beauty through the Westbrooks call, we ride, or do we talk about settlement, which I'm sure they aren't inclined to do at this point based on everything that's gone on. But it becomes their decision. Do we ride? Do we not? They sent multiple cease and desist over 18 months and decided to file suit. I can't see them just dropping it now. I feel like they're just in this till the end of time because of how much has gone on. Could Tati file for emotional distress against Brown KJ for dragging out jurisdiction with useless filings? No. No, they can't. First, litigation privilege. Second, it is the right of the parties to bring the motions they deem necessary. Yes, there can be other consequences, but in the realms of litigation, no, protracted litigation does not subject you to emotional distress. But it'll be interesting to see if they file stronger cyber harassment charges in Minnesota. So that'll be very interesting to see. Is it possible that Tati is over it and won't refile? Always possible. It's their choice. I can't imagine that happening. You guys tell me, what do you guys think? What do you think? Do you guys think that after everything you've seen go down that they'll refile, or do you think they'll just walk away? Let me know in the chat. I'm curious what you think. How much do you think all this process cost? Each party does pay their own lawyer's fees at this point. How much do I think all this costs to get to this point? I mean, we're well into six figures would be my estimation at this point. Question, do you think the Westbrooks will continue to ask for a jury trial in Minnesota? What's the advantage of having a jury trial in a civil case? It depends. I mean, they will absolutely talk to local counsel. I think when you bring in a jury, there's a lot more... there's a lot more art to it. Judges look at things in a more black and white way. They look at the law and the facts, but the story of it all is not as impressive to the courts. Like, they've seen it, they've heard it, they've been done there. They don't care. Juries very much more will get involved in the story of the thing, in the, oh, but then this was said and that was said. The way that we all are involved in the story of the thing, the videos, the statements, looking at the parties and what happened with the parties. A jury gives you a very good opportunity to get things like punitive damages, like, hey, you suck damages. And a jury also brings a different kind of heart to the case that you don't always get if you just do a court trial. And it's their absolute right to ask for a jury trial. Does that mean down the road they can say, okay, we don't want a jury trial? Not really. I think they will ask for a jury trial again. We've seen them ask for it before, because I think it allows them to tell their story. And if what Tati wants is to get up and tell her story about what happened in all of this, a jury trial gives that opportunity. Also, it would necessitate KJ being likable to a jury, and it would necessitate Tati being likable to a jury. And you guys can tell me how you think that would go before a jury of people who have no idea what YouTube is and don't know anything about this. They would get to see the story from both sides and then decide. No, there's no waiting time. Sorry, I forget to just ask the questions. How quickly can they file in Minnesota or this week, or is there a waiting time? It depends on what they need to do on their end and if they choose to do that. Could Tati strategically take a wait and watch strategy? We know KJ deletes stuff, and her six-figure bill might actually slow down her desire to continue making Tati videos. She can do that up until a point, because at some point there is a statute of limitations in all states with how long you can wait before you bring certain charges and certain cases with regard to certain statements. And some of these videos in the complaint were older. The Pacer article, I don't remember the exact date, but that Pacer article was not super contemporaneous. And I can pull up the complaint in a minute and see where the Pacer article was, because that Pacer article, let's just see, because I've got the complaint, so might as well just pull it up. And I'll scroll through that while we're talking, as I'll just pull it up on the screen and scroll through it while I'm talking, because there will be timing that will need to be considered as well. So that's my answer to the wait and watch. Let's look where it says Pacer. It normally gives, I think it gives a date on when that Pacer article was filed. Let's see, because the Pacer one had quite a lot of the statements, and a lot of the statements that were interesting to me because they were connected to, I thought, some of the Swanson complaint. They kind of echoed one another. So this is talking about the 40 YouTube videos since May 2019. So that's not substantially old, May 2019. I mean, we're not even in May 2021, though it's coming. But I don't imagine, most of these things have a 3-year statute of limitations. Could there be a 2-year statute of limitations? Possibly. Most things have a 3-year statute, if not longer. Some things have a 1-year statute, but those tend to be less serious things. So let's see. And then so then the Pacer, or the Pathos article was June 3rd, 2019. So we've got May 2019 and June 2019. So if on the shorter end, those are a 2-year statute of limitations, we're in March, so they'd want to file before May. That's plenty of time. But that is, again, hypothetical, because I have not looked up the statute of limitations for everything in Minnesota. But we can ask Ricada. Question, does KJ's claims against James regarding his mom's death count as malicious? So if James Westbrook, and malicious doesn't really mean mean in the law. Malicious in defamation means with like reckless disregard for the truth. So malicious disregard for the truth. I think that what was said in the court records in Hawaii are not what KJ said they said. And so if James is a public figure, that counts. If James is not a public figure, you don't even need to get there. So I think there will be argument down the road about whether James is or is not a public figure. We'll see. And then with regard to some of the other statements, like some of those allegations may be defamation per se, but this case has been dismissed. So we'll have to see if defamation per se is filed again, if this is refiled in Minnesota. Oh, I don't doubt it. I mean, technically, this case has absolutely been dismissed. That's what the judge said. It just doesn't mean that it's over. Question, as a lawyer, do you prefer Westlaw or Lexis for legal research? So in law school, I used Lexis, and the DA's office had Westlaw and Lexis, and I found Westlaw easier, and I still use Westlaw today. So that's just a personal thing. Keem. Keem came. See, I went back up in the chat, and that's where you came in. So I am hoping for a Ricada breakdown of the Minnesota law. Question, why didn't Babs look at the perjury aspect? It was never brought before the court. That's why. And could that still come up? There are circumstances where that could, here, as I moved on, but shouldn't have. There are circumstances where that can still come up. If discovery shows that there were things said to the court that were misleading, could that come back up? Yes. Could Lori Ann still file a complaint against Brown? Yes. I still have concerns about the information and communications he shared. I do too. And yes, she could. Question, if KJ repeats what she said in her declarations, will Lori Ann come back? Well, Lori Ann really was in this case with regard to jurisdiction. And so Lori Ann's a Washington resident, and that jurisdiction isn't a thing. It's not going to be an argument in Minnesota. Like there's jurisdiction there over defendant because they live there. So that's jurisdiction and diversity jurisdiction, subject matter jurisdiction isn't going to come up in Minnesota. Those arguments really can't be made if this is refiled there. Question, is it possible they already have stuff ready to file in Minnesota? It's possible. And a lawyer, just in case this happened, and can file ASAP? Yeah, absolutely possible. Because any lawyer looking at this and looking at the personal jurisdiction knows that personal jurisdiction, when it's not a slam dunk, look, it's a slam dunk when the person lives there. It's not a slam dunk anywhere else. Is there argument that like the court could have done this, the court could have done that, the court could have issued discovery? Yes, they didn't. Babs said, no fucking way, get out, get out, get out, oh God, get out. So could they have a contingency plan for this? I mean, they absolutely could have. And I imagine that was part of early discussions with, if we file it here, these are the things that could happen. And if we file it here, these are the things that could happen. Could filing in Washington first have been a strategy? Yep. Could have. Could it have been a just, we want it to be here because if they concede to jurisdiction here, then we just move on to jurisdiction here? Could have been, but I don't think this will end the case. So that's my thoughts on it. I don't think it'll end the case. Question, I think that's the right outcome, but I'm going to miss the entertainment. Fair enough. Will you cover the crazy cheerleader deep fakes case to fill the empty hole this will leave? I think it's probably nice to have a break from this particular defamation suit for everybody. I have not dug up any information on the crazy cheerleader deep fakes case, but I'm fascinated as you guys have started sharing it with me. I'm fascinated to hear about this. Does this mean they get a brand new judge? Yes. It will be, I would imagine, in federal court in Minnesota because there's diversity jurisdiction there. So yes, new judge. KJ would need a new attorney. Yes, she could still have Brown on her team. That is a choice. I wouldn't personally choose to pay for two attorneys when I could only pay for one. So we'll see what happens. Question, doesn't the passing of more time now diminish potential impact of the alleged defamation? Won't it become more difficult to prove damages the longer this goes on? Yanni, always a possibility, but it depends on, you don't have to prove defamation, you don't have to prove damages right this second. If when these videos came out, the Westbrooks and Halo can show damages, then that's what matters. And damages can be minimal, especially, there's two parts of damages. There's damages to establish that the defamation caused harm. And then there's damages for like, pay the bitch. And so the damages for caused harm don't have to be massive. They have to be damages. You have to prove some damage. And we've already seen at least two people saying, I stopped buying Halo because of what KJ bought. Is that legally sufficient for damages? I think so. But does that get you paid? No. Do I think Tati is going after this lawsuit to get a payout? No, I don't. I think this is a I finally had to stand my ground suit. So that's what it is. Yes, this case was dismissed. Any updates on the hacking? It is with the FBI. Could Brown have purposely made so many filings about Lorianne to sidetrack Saltz from making a stronger argument about jurisdiction, knowing that the court would need more to decide? No, I don't think so. Why? Because Saltz already made all of his arguments with regard to jurisdiction before any of that happened. Could it have been to annoy the court? Maybe. Could it have been, I don't know, to run up litigation costs before he was out of the case? Maybe. Could it have been that they thought that's absolutely the thing that they had to do? Yep, sure. So the Lorianne stuff came later. I think that the defense saw the Lorianne declaration as an issue for jurisdiction. The court didn't see it as an issue. The court was like, this just isn't enough. And that's a fair decision. Let's see. Keem and I will have to go. If this gets refiled, we're going to have to chat about it because we'll see. Although on notice, if misunderstood and party deletes stuff, what would happen? Oh, that's all kinds of monuments to the gods of speculation. Look, there's a duty there. It will come up. We saw in the original motion to not delete your shit, there can be jury instructions, there can be fines, there can be court orders. I hope that won't happen. So I hope that everybody will just do the things they're supposed to do. I asked the channel members about this. It seemed a lot of you wanted me to cover this. I have not read the complaint yet. So will I cover it? Yes. Will I cover it this second? No. I will not. Oh, my yeah, yes, I do. I was behind on the chat also getting to questions. If I missed questions, I'm sorry. And I know I missed a few super chats. And for that, I also apologize. Simply Me MJ said, does SALT stay on? How soon would filings happen? SALT can appear pro hoc vice in Minnesota, just like he could in Washington. How soon would filings happen? It really depends on them. So it depends on all the things we've aforementioned. Schmidt, I think it's Schmidt, Schmitty, KR. Sorry for butchering that. Absolutely. Question, will the amount of social media malarkey in the Washington case have any effect on soliciting local counsel in the new state? Maybe. Would opinions formed on social media behavior have an impact on whether or not a Minnesota firm would accept the case? I mean, it's possible. It just depends on which side of it is. And if there's so many ifs in that, it really depends. And it depends on whose side is looking at it. So us lawyers looking to come on KJ's side are going to look at different factors than lawyers looking to come on plaintiff's side. So it really just depends. Could it? Yeah, some attorneys might look at it and be like, no, I'm not touching a YouTube case. Don't want to do it. So we'll see. There's also attorneys that deal with that kind of stuff all the time and are like, yeah, whatevs. So hopefully I just had another super chat pop off. I'll go find it. If it gets refiled in Minnesota and Tati loses, is there any way KJ can get her attorney fees from both cases? It depends. So it depends on so much. It depends on how it is lost and what is lost. But with the Washington case, I think it would be hard to go back for, but it really does depend. It depends. So I'm sorry that that's such an it depends, but it just depends. I don't know if Brown dodged a bullet yet, because stuff can still happen in this case. So question, can YouTube still have a problem with the mass flagging accusations? It can, I think so. Will YouTube do anything about that? I don't know. Will the channels who got mass flagged that were mentioned in the Lori-Ann declaration take that to YouTube? I don't know. It can happen. It absolutely can still happen, but that's up to the platform to deal with it. And the platform's going to have to, it's going to have to be brought to the platform's attention, and they're going to have to deal with it. Now, did I speculate about this because SALT is working a case with YouTube? Yep, I sure did. I will still speculate about it because SALT is still in the Hubbard case with all the counsel from YouTube and from Google. So, that's still ongoing. So, SZ Seltzer says refile within a week. Fair enough. I'm looking forward to you talking about defamation and YouTube drama channels. It's something we're going to continue to see. And I think continuing to go over what is and is not defamation, because there's a difference between defamation and cyber harassment. Going over those things, I think, helps inform the whole community about where the lines are and where too far is. And the laws are still trying to catch up with where the lines are and where too far is. I hope the chat gave you a quick 10-second rundown that the court dismissed this case based on lack of personal jurisdiction. Is it even smart for Tati to refile? This is extremely costly. It's public knowledge that KJ spread misinformation. And is KJ losing her job really worth the cost here? Aurelia, I can't answer that question. That is a question solely for the Westbrooks to answer for themselves. So, I mean, I don't think it will get better if they don't refile. Was there a ruling on all the attorney's fees? The motion with regard to sanctions was denied. So that was the ruling. It was denied because the court no longer has jurisdiction. The court is like, bye. You've talked a couple times in your coverage about research attorneys. What exactly do they do, and how does someone become one? Prospective law student trying to learn all I can. Piper Ann, great question. Hi. So research attorneys work in different ways depending on the court, but they are the attorneys that work for the judges to help do the legal work, to do the research, literally behind all the rulings. This is something that generally people can do right out of law school. Later on as a career, it can be done for a year, depending on the court, or it can be done for a complete career for the court. A lot of people will work as research attorneys in different courts to gain experience out of law school. It is a great experience. I worked as a research attorney. I loved working as a research attorney most of the time. Sometimes the days were very long. There's a lot of work to do. I worked for 2 judges. And in my work as a research attorney, I took in motions like this, read them, took the law, read the law, briefed them for the court, sometimes helped write rulings, and then worked with the judges on what was coming up the next day, sat in chambers with them at the end of the day and talked about what had gone on that day, but spent most of my time in a room with a computer and stacks of motions, reading through stuff like what went down in this case before I became a district attorney. So that's what research attorneys do. You can do that in most cases after you pass the bar, but in some cases when you're waiting for bar results, you can work as a research attorney while you're waiting, because the research you learn to do in law school holds very much, and you're not appearing in court. You're working behind the scenes on behalf of the judge. That's exactly what Babs said. That's exactly what Babs said. That's exactly what she said. Y'all have to get out. I am done. I think KJ was hoping they wouldn't refile. I'm sure she's hoping that they don't refile. I am sure she is hoping that. And I think it was said she got out of other suits that way. I don't have any knowledge of that. I have seen that said too, but I can't imagine. Jody, he sure could have done all of that to make it so the court was disinclined. But if the court didn't go that way, then it would have created quite a lot of problems. So anyone's strategy is their strategy. So I'm going to try to look for a few more questions. Thank you. I'm trying to get to the super chats. I am trying. I am behind on the questions, and I try to get to everybody's questions and not just super chatted questions, because I do believe law is a conversation, and I do want to make sure that everyone can ask questions and not just members and not just super chats. So that is what it is. Question, can collusion of others on the KJ's behalf be listed? I'm not sure what that is directly referring to, so I can't answer it. Because I just don't have enough information on that. We will always have monuments to the gods of speculation. And to me, that was worth it. Rena, to me, it's worth it too. I think we definitely saw some very, very interesting filings in this case. We've all learned quite a lot about law. And I think that for better or for worse, we have gotten to cover very interesting aspects of civil procedure. And we've seen wild shit, stuff that flabbergasted me in this lawsuit, which is interesting to all of us. Question, Kid Lori Amby, it depends on, we still don't know all the facts that are known to these parties. We only know what's been put in the public forum. We don't know everything that Tati knows. We don't know everything that KJ knows. So what they would bring on a cyber harassment is going to be up to them. And if they file it, we will see it. How do we find each state's cyber stalking and cyber bullying laws? They're on the internet on things like FindLaw. Yes, Jennifer Wilson, they lost. The Westbrooks lost jurisdiction. KJ won the motion to dismiss because it was granted. Question, is it easier to prove defamation in other states? If so, would it have been smarter for KJ to just fight the suit in Washington? I think it might be easier to prove defamation in Minnesota. And if it gets refiled there, we'll do a breakdown of that. It would be harder somewhere like California. So yes, different states have again, different laws that can be easier or more difficult to prosecute or defend. And by prosecute, I mean put forth, not like criminal prosecute, but to, yeah, hopefully that made sense. Question, would it be helpful for the government to designate a specific court state for internet cases? I don't know. I don't know. I don't know. I don't know what the answer is with regard to the internet and with regard to rules of the internet. And the courts are still trying to parse it out and trying to balance the rights of individuals and the harms of the internet. And it's going to be interesting to see how that keeps moving forward. Question, if there was a YouTube channel that reviewed products and the brand being reviewed didn't like the reviews, can the YouTube channel get sued for defamation? Just not liking what was said is not going to be sufficient. And we've talked about defamation a lot. Defamation is not just, I don't like it. There are actual rules. I'm going to look on the back end for a few of the super chats that I missed, because I know I missed a few and I try to not miss them. But if I miss them, I apologize. Chronically B Queen said, I'm wondering why it was dismissed. Well, we've covered what Babs said, and I think the reason that the court ordered it dismissed and not ordered additional discovery was because of how messy the court saw this litigation getting, and it was just like out. Audrey Shade said Babs is over it. Yikes, Babs was definitely over it. But again, you can only, you pull that once. Okay, so it gets dismissed. Everybody's spent a lot of money. If this gets refiled in Minnesota, we're right back to the beginning. Is it worth it for the parties? The parties will have to decide that on their own. Crooney said Babs really decided to send the children to a military boarding school with that jurisdictional dismissal, possibly. Angel said, without Lori Ann's deposition, help Tati with the damning information she had receipts for and her own personal insights on KJ's behalf of this entire case. I mean, I think the information gleaned from Lori Ann can absolutely help them move forward, depending on what wasn't in those declarations that was contained in all of those conversations. Octonation, thank you so much for the super chat. King Frederick said, been loving your content. Keep it up. Thank you. Rena said, closing time, all the doors, and send you all out of my court. Absolutely. Closing time. Open all the doors and send you right out of my court. Goodbye. Thank you, Rena, for that super chat. Michelle S. said, question, with the file dismissed in Washington, is KJ free to delete files? I think I've already talked about that. Bab said's not here, so KJ is delete, delete, delete. I hope not, because I'm sure her attorney has advised her what she can and cannot do, and that is between her and her attorney. There's still, I think, notice of pending litigation here, just like there was in October. Lisa Lee B said, can Brown leave this whole thing now? Yes. Also, Babs is like, closing time. You don't have to go home, but you can't stay here. I love the closing time references. I have actually been working on a Spotify playlist for every time I break into song on this channel. So closing time is going to get added to it. Ye Cats said, since Babs rules, this means we're done with Brown forever, right? I think so. Sadly, we lose Jazzy Jeff too. Yes, we do. Thanks for always writing, Emily. You're welcome. I enjoy breaking these down and seeing the court rulings just as much as you do. Susie Italiano said, is it possible that KJ and Tati settle behind the scenes? Always. So that Tati won't file in Minnesota? Yes. If in return, KJ makes no more videos about her ever. What a settlement would look like, I don't know. These parties are fairly locked horns. Anything is possible, but these parties are fairly locked horns. I don't see Tati reaching out to say, hey, let's resolve this. I imagine, again, speculation, that would have happened when these cease and desist were filed. Like, hey, we're telling you to knock it off, or we're going to sue you. And we can have a conversation about us not suing you now. Once we've sued you, I don't know if that ends the conversation. Is it always possible for parties to settle as cases move forward? Always possible. Sinead Bryn said, probably a stupid question from someone not in the U.S. Is this in federal court instead of state court due to the fact that the parties are in a few states? Yes, that's exactly why. Diversity jurisdiction. Exactly. It's also easier to subpoena stuff in federal court, amongst other things. But yes, diversity jurisdiction is the basis. They could choose to file in state court, but then you would have to do some subject matter jurisdiction stuff. And I think it's just easier in federal court. Bethany gave a super chat thanking the mods. Yes, thanks the mods. Jason said, give Nate the lawyer props. He was the only lawyer to say it was going to be dismissed on jurisdiction. I think everyone said it was possible. Nate was like, it's happening. Because there's always possibilities, right? Christina Mengen said, Babs, mic drop. Yep. Simply Me MJ said, does SALT stay on? How soon would filings happen? I know I've answered that. Jamie G said, I would love them to refile tonight. I don't think that's going to happen. Keep head spinning. Emily, thank you for your work. You're welcome. Selena says, Babs, not my monkeys, not my circus. Accurate. Sussex said, I'm assuming that KJ will announce on social media that she is one. She will be even more insufferable. She'll do what she's going to do, and Tati will do what she's going to do, and we'll read the documents as they get filed. And I think with that, I'm caught up. Meriden, I think I had this question. How will everyone find out if this is filed in Minnesota? It would probably be on Pacer, because I think that they would file it in federal court. So then it would be on Pacer. My chat just jumped and I missed a few things. I'm going to try to catch these super chats and then go back and get some questions. Best thing about this case, I found your channel. Dawn, you're not alone in that. So there have definitely been some positives for me with this case, for sure. I've gotten to know a lot of other creators, and we've really gotten to talk about the law, but also like a lot happened. A lot happened. They're going to the ranch, says Matt. Yeah, a lot went down in this case, which is interesting. But again, jurisdiction, do we want creators to be able to be pulled all over the country? But do I think KJ does the most when it comes to what she does? Yes, but that's not a court ruling. The court decided. Question, as to jurisdiction, future space travel, do you think it would happen future-wise with cases that may deal with crimes and civil things that happen on international space missions? Completely off topic, but curious. That's a much longer discussion. So this comes up in things right now, and I could analogize it to things I know. This comes up right now in things like cruise ships. Where cruise ships are flagged is where the law is. So if you're on a Disney cruise and the ship is flagged in the Bahamas and something happens, the law of the Bahamas applies. So do I think that would happen? Yes. Or something like the International Court in The Hague would be like, okay, anything that goes down in international in space, could it be flagged to a country, or could it just go to the International Hague? Maybe. The law is going to have to keep up with the way the world keeps changing. Question, now that the case has been dismissed, if KJ goes back to harassing Tati, I hope that won't happen. Can Tati use any new comments from KJ? They can refile with whatever they want to refile. So they can refile with anything. They can refile with stuff that's happened since this case got filed. They can choose. Team Rocket blasting off. Maybe Matt Bond. If KJ runs out of money, doesn't have representation, she can't get a lawyer, so it moves from there. Or she would appear on her own, because one can still represent themselves in court, though, generally not advised. Motion to get an interview with Jazzy Jeff. Oh, poor Jazzy Jeff. I don't even think he wants to discuss this case. If this gets refiled, it's still going to be an ongoing case. So all of that will have to wait, because it will still be an ongoing case. Thank you for the super sticker. What would happen if Tati refiled in Minnesota and KJ couldn't afford it? She would represent herself, I would suppose. And that's fair, because this is dismissed. Question just gone on. Hope you haven't answered it, but could KJ still be facing perjury charges for lying in her declarations? It really depends on what comes up with discovery, and could there still be consequences of things that happened in the Washington case? Yes. What will those be? We will see, but those have to be brought up. The court's not going to do it on their own. So let me see if I missed any other super chats. I don't think that I did. Hello, Just Brit and Co. You're welcome to be an official Law Nerds Lurker. We have been talking for an hour and 45 minutes. I'm going to do a few more questions. No, not yet. I think that this will get refiled. We'll see. We'll see what happens. I think that this will get refiled. So Matthew super chatted and said, no more Brown. I don't think so, but could he appear pro hoc vice in Minnesota? Sure could. Would KJ choose to hire a Minnesota attorney plus bring Washington counsel in? I don't know. It seems like a waste of money. Is anything possible? Yes, anything's possible. So, because really, truly, anything is possible. Petition for an interview. Well, we're going to have to wait till it's all over. Question, would you interview Babs if you could? Oh, I would absolutely, but we can't. This is still, yes, I would if we could, but we can't. I would love to know what happened behind the scenes, but more than the judge, I would love to know what the research attorneys have been through with this, but that stuff we're not going to get to. We're not going to get to know, but it would be fun to know what the research attorneys thought of all of this. And maybe one day we'll find out. Question, it goes both ways, right? Creators who defame non-creators, fans. I can think of one channel that did that. It's a true crime channel and they falsely accuse people of stalking and swatting. I think the question is with regard to jurisdiction and pulling people from different places. It goes always. Like jurisdiction is one of the first things you have to prove in a case. And we've talked about this a lot. And when you choose to sue, it's one of the conversations that's had when a lawsuit is brought. It's why, criminal cases are things that arise within the location where they're being prosecuted. The thing happened here, so this is where it's being prosecuted. And then with federal stuff, it's having to show the relation of what was done and where it was done. And that would be the same. It would have to show what was done and where it was done. I think that's regarding to jurisdiction. Question. So now that this has happened, what is YouTube going to do? And should they play more of a mom and what others say about each other? So the question about how platforms regulate content on the platform is a way bigger conversation than just this case. This case highlights issues with that, but it's bigger than this case because what we've seen on other social media platforms is where are the boundaries of free speech? And yes, First Amendment free speech is protected against a government actor, but open speech and censorship. And those boundaries are something that has to be explored by the social media platforms and really by us as kind of an international internet community, because you can say things about people that are hurtful, that are vicious, that are mean, but aren't necessarily defamatory. And a lot of stuff online skirts those lines. And so, there's a difference between whether a platform just doesn't like it or whether it is actually legally actionable and who's the one that makes that determination. And that's where all these debates over Section 230 and open speech come in, because I think that open speech is good, but also where's the line and where are people, allowed to stand up for themselves. So if the platform doesn't take action, then we have to have individuals taking action, and that can be very difficult. So that's really where the bounds are. Do we value people being able to say what they're saying? And if they cross the line, taking that up with a lawsuit? Because if that's the case, then that's how we're seeing it play out here. Or at some point, do platforms have to step in and enforce their own community guidelines? And how is that done? It's a balance of rights, really. And it's a balance of desires. Do we desire open speech? And then if that goes too far, people can sue? Or do we desire platforms to more heavily regulate or censor the speech on their platforms? And I think that for everyone, those answers might be a bit different. So yeah. Any news on Tay Tay and Evermoist? I have not looked in a few days. We talked about the new lawsuit that she filed, and I have not followed up since that new lawsuit was filed. In what situation could Brown refile the motion for sanctions? Well, he can't refile it really in Washington because no one has jurisdiction over the court. It would be really hard to bring it in the Minnesota court because it's not relevant. So I would have to think about it because I'm sure there is an answer to that. It's just I have not thought about it. Let me get to a few more questions. Yes, it might be a while. It might be a while. The question is, could Salty sue Brown after all of this? No, there are still litigation privileges. So for what goes on between the lawyers in the course of litigation, a lawsuit, like a civil lawsuit, no, there is still litigation privilege that protects a lot of what has gone on because you have the balance of ethics and vigorous advocacy, right? And so that gets into all of the realms of litigation privilege and the things that are covered by litigation privilege. Oh, sorry, Linz, thank you for asking. What is pro hoc vice? You've mentioned it a few times. Sorry if it's spelled wrong. It's not spelled wrong. That's brilliant. It's when an attorney from one jurisdiction, an attorney like Salt's licensed in California, appears for this matter only in another state, and it's normally with a local attorney. And we saw that in this case where you have Jazzy Jeff and his law firm are a law firm in Washington. They're licensed in Washington. Salty is an attorney licensed in California, appearing in a Washington court with local counsel for that matter. So Salty's not licensed in the state of Washington, but can appear in Washington court for that matter. So that can happen in other courts too. And we see it. It's not uncommon in cases. I'm sure she has said that. I have not said anything defamatory. Can anyone sue anyone for anything? Yes. But yeah. Can anyone sue anyone for anything? Yes. And we've talked about that on for sure. No, this merch is up. New merch drop. I have a few things to finish in the store and I was not expecting to be live. So the new merch is supposed to be up today. It might be up tomorrow because I still have stuff to finish and it's spring break. So I still have stuff to do with the kiddos and the brand new kitties. So it might be up tomorrow, but I will keep you posted on socials about the new merch drop. And if we get delayed with the new merch drop, I will keep it so we have time. Everybody will have time. Why did the judge mention the other lawsuit Tati's in with Salty? The judge mentioned it because it's in the complaint. So the judge was talking about the fact scenario of the complaint, and that was mentioned in the complaint as well. When will we know it's all over? KJ, I'm sure she decided to make a video. When will we know it's all over? I mean, we won't unless the statute of limitation expires and Tati doesn't refile. I mean, that's when we will know. Let me see real quick. We're going to do a real quick, we're going to noodly Google. The mods are like, but we're at 2 hours. Yeah, I know. Let's see real quick. This is a real quick. Let's see what we can find real quick. And again, don't quote me. We're looking really fast if we see any immediate statute of limitations issues. So Minnesota, a 2-year statute of limitations applies to defamation actions. So in May, if some of these statements, it says some of these statements were made in May 2019 and some of them were made in June 2019. So 2019, 2020, 2021, if we get past June, then we can start to have a conversation about that. I imagine it will be refiled before then if it's going to be refiled. Question, is the order to not talk about things on social still in effect beyond just being a smart thing to do? Again, the court's advisement to the attorneys was a smart thing to do. The attorney's advisement to the parties, the court no longer has jurisdiction. So again, if the parties talk about this case, they can talk about this case. Is it advisable? We saw how it blew up in this one. And anytime a case blows up with more filings, it's just going to cost more money. Let's say KJ hires new attorneys in Minnesota. I'm sure that will happen. What does the turnover process from Washington lawyers to Minnesota lawyers look like? So normally there would be a complete turnover of everything, including work product, because it's representing the same individual. So that would be behind the scenes phone calls and like, this is what we've learned. This is what you know. So how will you know if they refile in Minnesota? It'll be on Pacer. So it'll be filed in the court and it'll be a public record. And sometimes y'all know before I know, so I'm sure it'll also be up on Twitter. Do both parties pay their legal representation even though it's dismissed? Yes. They have to. I mean, I should say, unless there is a fee agreement or a contingency agreement that would state otherwise. Generally, that is the case. And we saw Brown put in his billing statement. So we've seen him say, this is how I'm getting paid hourly. So it doesn't seem that this is on a contingency of some kind based on what Brown has filed. Does terrible motion to dismiss now set bad precedent that even with a badly written motion, you can still win? I mean, Ray J, even with a badly written motion, you can still win. That's absolutely always the case. Because the law is the law is the law. And at this case, the court really relied heavily on what do the plaintiffs say the facts are? Does it match what the law is? And is it enough? And the court looked at it and went, nope. The plaintiff says the facts are this, and this is not enough. I think the amount of filings in this case leaned the court away from granting discovery and leaned the court into dismissing the case. So I have seen questions about David Dobrik. You guys, we're not talking about David today, but there are no, there's no open cases on that. And I've covered it in other videos. So thank you for asking. I'm just trying to stay on topic with KJ defamation, Tati Westbrook stuff. I didn't see any comments KJ made about me. I'm sure she's not a fan. I really don't care. If Tati's side indicates to KJ that they're going to refile, could KJ approach them and ask to settle? Anything can happen at all. So anything's possible. Unrelated to the case, but could you talk about your experience working with forensics? I'm interested in forensics and would like a lawyer's perspective. Oh, Holly, it's a long conversation that we can definitely do in a Q&A video. It depends on the types of forensics, computer forensics, physical forensics, always very interesting things. No more Brown equals no more 45-line paper, right? Right? No more 45-line paper. I'd refile fabricate Tati just for the point of it. I mean, Christy, I'm sure that there's feelings involved on both sides. We'll see what happens. Can Saltz keep all the declarations he filed in his motions, or are they now invalid? I mean, they were written for a particular circumstance. So they've already been filed. It doesn't make them invalid to be filed differently, but some of those things aren't going to be relevant because they all went to jurisdiction in the motion to dismiss. So it's not like you would refile them because they're not relevant in the next thing. Do those contacts with those individuals still matter? Yes. Could that come up again when it comes to damages and stuff? Yes. But you wouldn't just refile the exact same thing. Jess, no, because there's no motion for that. And there's no indication that this was, a case that was filed without any merit. If the court had said something different, if this had been dismissed on different grounds, there's room for attorney fees depending on the grounds of dismissal. But this was the court just saying, hey, we don't have jurisdiction here. And that's something that the court has to determine, but the parties can file where they want to file. Why do you think there are so many channels banging on about Chris Watts? Is it all for, I have no idea. I don't have any speculation on it. I'm going to answer a few more questions. Does James Westbrook stand a better chance of going forward with this lawsuit by himself, Little Red Star? I don't think so, because all of the counts get evaluated on their own. So there's evidence that goes to all things, and then each thing gets evaluated by itself. So at the end of the day, if a jury depending on what's brought, right? Because now there's this case has been dismissed. So now there's no active complaint. Based on what we saw in the other complaint, there were quite a lot of different incidences that went to different counts. If that holds true, if this is refiled, then a jury down the road would say, okay, these statements look like they are defamatory towards Tati. Statements like she has a criminal record or whatever. Those statements look defamatory towards Tati, but these other ones, we don't think they match. So you can win some counts and lose some counts and still win and lose. It just then depends on how much you win and lose. Does this mean the Halo Beauty lawsuit is next? B. Vega. With the Halo Beauty lawsuit, the business partner lawsuit, there is a motion to dismiss for jurisdiction in that lawsuit and a motion to remove the case. I think that case will end up getting moved to Nevada. So we'll see. I think that case will end up getting moved to Nevada on jurisdiction grounds based on what we've read on it. Question from Megan, is anyone else still sus about where KJ is getting the money to pay for this? I mean, that is between her and her attorney and her bank, not us. Does Minnesota have local rules regarding 45-line paper? We'll see, because those tend to go by court and sometimes judge by judge. Question, what's the most times you've heard a case being dismissed for jurisdiction? I mean, normally only once, because then you just file it where the other party lives. So normally it would only happen once. It does happen. Jurisdiction is always something that can be evaluated if you choose not to file where they live. So at the end of the day, where we're at is, thanks, Octo. At the end of the day, where we're at is a lot of money's been spent and it's a do not pass go, do not collect $200, go directly to the beginning. If they refile, if they don't refile, then it's a win for KJ because they chose not to refile. And as much of a win as it would have been if they had sent all the cease and desist and never backed them up at the first place, just more costly. So if they choose not to refile, at the end of the day, everybody's out a whole lot of money and nothing really gets resolved. If they do refile, then you're in Minnesota and you're starting back at the beginning. Dylan Reese says there was a DA that noticed the witness and defendant were in the same house. If you're familiar with the situation, could the witness be held in contempt? It's one of the things I've been sent a lot, the video on it. I have not looked at it. I'm going to look at it because so many of you have asked and talk about it possibly tomorrow during Coffee and Cursey Words, because we still have Coffee and Cursey Words. Could KJ's Minnesota lawyer that made the comments early come onto her case? I mean, if that's who she chooses to hire, they absolutely can. It's absolutely her choice. Question, are you aware that my lionated parent now says y'all the same way you do due to the amount of times you've said it during this case? I hope that's not a bad thing. Because y'all, this case has been a very, very interesting one, hasn't it? I'm going to get a few more. I've said I'm going to get a few more questions like 700 times. If they choose not to refile, would this hurt Tati and James in their business suit if they were not adequately defending the Tati Beauty brand? Jordan, I think there's an argument there, but also, yeah, I think there could be an argument there because when it comes to the business partner suit, there's an argument that they have not done enough for the brand, that they owe a duty of loyalty to the brand, et cetera, et cetera, et cetera. So could the argument be, look, you filed it in this jurisdiction and it got dismissed and you didn't go to this other jurisdiction? Could be. I mean, I think Halo Beauty is probably paying the legal fees in this case because they are a plaintiff in this case. So it's like 6 of one, half dozen of the other in the business partner suit, right? It's like, well, you need to keep going, but also the company's spending money on it. And so it becomes this push and pull, which is also very interesting that this company is involved in multiple lawsuits at this time. And we will see what happens. Have you seen the Fortnite lawsuit? I sent it to your DMs. Haley, I have not seen the Fortnite lawsuit, but I'll take a look. So, all right. The mods are like, please wrap it up. I know. We have 6,000 law nerds in here still asking questions. Dinner's ready. It's a great question. It really, really, really depends on the state, and it depends what the cyberbullying rules are in each state. Cyberbullying rules, I think, are behind, and the cyber harassment rules, I think, are behind. And it depends state by state. I think it's probably something I should just do some content on to help talk about. But, the line between defamation and harassment leans towards the damages. In defamation, you have to show business damages, where harassment, you can show damages to yourself, to your mental health, things like that. And that is something I see creators struggle with more than you see creators struggle with actual loss of revenue due to defamation. It's the emotional and physical and sociological impact of sustained harassment. And that's, I think, a line that the channels that make hundreds and hundreds of videos on one topic, if it's just and then this happened, it's different than and they suck and they're awful and they do this and they're name calling and things like that, stuff that teeters that line because it's not maybe causing defamatory damage, but it is causing some other type of outcropping. So the laws on cyberbullying are not perfect and are growing, and they don't have them in every jurisdiction. So yeah. So question, could Tati go after Brown and KJ for running up? No, because again, what happens in litigation happens in litigation, and things that are filed, you can't, the stuff that Brown filed, I've talked about it. I don't agree with everything that was filed. I'm like, why in the world is this what you're doing? But I also can't sit here and say, did he have absolutely no reason to do those things? No, you can't say that he didn't. He clearly believed that he did. So, and that would all be handled internally with the court, which is why you saw the court in this ruling saying there would have to be extensive evidentiary motions to deal with these allegations, because there would have to be extensive evidentiary hearings to deal with this stuff. And the court was like, no way, we're not doing it. We're not doing it. Question, in the refiling, can they just add information that was determined or found due to the jurisdiction fight? If there's information that's relevant to charges in a new jurisdiction, yes, they can add things. Like if things happened that weren't alleged between the two, then they absolutely can. All right. Questions. Will Tati come back to YouTube after this? It depends if they refile or not. So it depends. It just depends. I'm going to try. That wasn't the question I was going for. I was going for the one and I hit the Nightbot instead. If KJ deletes all the things, but Tati side recorded them, can the recordings still be used in court? Jessica, yes and no. So yes, and it depends. Hopefully that helps. Yes, and it depends. Because as my brain is, it's time to wrap up when the brain is starting to stop. Because they still have the evidence of what was said, it becomes an issue with regard to the back end stuff. But I imagine at this point, there's already a motion to preserve. But there's still a duty to preserve on the individuals. So can Lawyer Cat come out? Lawyer Cat's going to have to come out tomorrow, Jakes. I appreciate that. But Lawyer Cat, yes, we will bring Lawyer Cat to Coffee and Cursey Words tomorrow for sure. Because I have real cats that it's time to go see. And it has been, look, this case has been a little bit of a roller coaster. Yes. I think Babs was like hell to the nah. Yes, I do, Chosen Life. I think that's exactly what happened, because with this ruling, she said there is going to be lots of evidentiary hearings needed and extensive time. The court was like, I'm not fucking with y'all. I don't fuck with you, is what the court said. The court granted this motion to dismiss on the grounds of I don't fuck with you. But also, there were always questions with personal jurisdiction as to what's enough. Is it enough? Where are the boundaries of enough? What has the case law said was enough? There's always a question of where is enough. And so now they can just go and file it in Minnesota if they choose to do that. So could KJ just always file a motion to dismiss and hope that no state will accept jurisdiction? Well, the state where she lives has jurisdiction, so there's literally no question of jurisdiction if it gets refiled in Minnesota. That it's not a question. So, y'all, it's time to go see. It's kitten time. It's time to go see the boys. It's time to go see Fred and George. It is time to go hang out. I don't know what that was about. I missed it. But it is time. It is time. It is time. It is time to go see Fred and George. Thank you guys. Tell all the mods a big thank you for hanging out. If my sister Sabrina is watching this, hi sister Sabrina, because the mods were like, we riding, and they were like, we got you. So much love to the mods. I will be live tomorrow at 11 a.m. for Coffee and Curse Words Central Time. Like always, we will answer some more questions. We will absolutely have conversations. I was planning on going over a different lawsuit tomorrow. We will see. When I list it up, you will see the topic because we had this. I was not expecting all of this today, but all of this happened. So we finally have a ruling on jurisdiction. And now we will see if it gets refiled in Minnesota. And we will chat about this again. But for now, I feel like the prologue is closed on the Tati Westbrook without a crystal ball defamation suit. We are adjourned. For now, we are adjourned. We are officially adjourned on the Tati Westbrook without a crystal ball defamation suit because the court has ruled, you all don't go here. I'm not the boss of you. Get the fuck out of my court and go to somewhere else. And the defense motion to dismiss based on jurisdiction was granted. The sanctions were denied. And that's all she wrote on this. So unless this is refiled in Minnesota, which I kind of suspect that it will be, we're adjourned officially. This is the first case we've adjourned on this channel. Adjourned. Thank you all for being here. I will see you in the next one. Do the YouTube things on your way out. It's much appreciated. I'll talk to you guys tomorrow at 11. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawneedsunite.com. Happy to have you. Support what we do here on the YouTube.